Hello, and thank you for joining us in today's webinar entitled Privacy Implications of Texas House Bill 300, What Should You Be Doing Now? This is the 13th event in the 2012 executive series of Fair Warning webinars. In 2011, the proceedings from the executive series were downloaded over 96,000 times. My name is Allison Matherly. I am the Senior Public Relations and Media Specialist at Fair Warning, and I will be your host. Before we begin the webinar, I would like to cover a few housekeeping items. We are broadcasting this through WebEx, and the audio is optimized to be heard through your computer speakers or a headset. If you are encountering sound quality or volume issues and need to join the teleconference, the dial-in information can be found on the Info tab at the top left of the screen or by clicking the phone icon on the right menu bar. I hope to have some time at the conclusion of the presentation for a question and answer session, and I encourage you to submit your questions as they come up so they can be placed into the queue for response. To submit a question, simply type them into the Q&A module that appears on the right side of your screen. We are recording this webinar, and a follow-up email is scheduled to be sent to you within 24 hours of its conclusion that will include the link to the replay as well as the materials presented. Additionally, the same information will be posted on our website at www.fairwarning.com. As you can see from the agenda slide, we are going to begin with our guest speaker, Ms. Amanda Ellis, Texas Board Certified Lawyer focusing in healthcare law. During the webinar, Amanda will share her expertise in advising healthcare organizations how to achieve compliance with Texas House Bill 300, as well as where current compliance activities can be used or slightly modified to fulfill new requirements. Amanda will also offer practical advice on what to tackle first and share her thoughts on keeping state and federal auditors, as well as licensing authorities, satisfied. We will then welcome Mr. Darren Peterson, Senior Solutions Specialist from Fair Warning, who will share his thoughts for year-end planning and privacy program considerations, including performing a privacy and security risk analysis and how to address regulatory requirements such as meaningful use stages 1, 2, and the pending stage 3. Lastly, time permitting, we will host a Q&A session. So let's get started. As of September 1st, 2012, with Texas House Bill 300 going into effect, healthcare providers in Texas have a host of new regulatory requirements with which to comply. However, many providers are still wondering where to start in fulfilling these new obligations. With these new requirements, care providers need to understand what is expected of them and how to achieve compliance with House Bill 300, as well as where current compliance activities can be used or slightly modified to fulfill these requirements. Additionally, care providers need to be able to evaluate their current privacy and security programs and plan for the future in light of an increasingly prescriptive legislative pathway. Our guest speaker is Amanda J. Ellis, lawyer from Austin, Texas, whose practice is limited to healthcare law. Amanda is board certified in administrative law and advises licensed providers on operational and regulatory matters related to their practices, including licensing, medical privacy and HIPAA, and Medicare and Medicaid issues. Before entering private practice, Amanda was an Assistant Attorney General in the Administrative Law Division of the Office of the Attorney General of Texas. She currently serves on the Council for the Health Law section of the Austin Bar Association, and it is my pleasure to welcome Ms. Amanda Ellis.
Good afternoon. Today we'll address the new Texas privacy law. It was House Bill 300 and HIPAA and high-tech compliance. The most important thing is what you need to know now. As evidence, first of all, please notice my disclaimer. This is not legal advice, but is information designed to help inform any inquiries that you'll make to your own legal counsel and those persons knowledgeable in privacy law compliance. House Bill 300 went into effect September 1 of 2012. Technically, all of these requirements are in place and are applicable to all current employees of covered entities. House Bill 300, in an overview, incorporates and expands the application of the HIPAA privacy and security rules and high-tech provisions. And it does so by broadening the scope of the rules to include entities that would not otherwise be considered covered entities under federal law. Texas has broadened this definition and imposed increasing privacy and security requirements in an effort to afford greater protection to the citizens of the state of Texas. As we know, with the most recent HITECH provisions, states were enabled to depart from the minimum federal standards to increase and enhance those standards and to choose to enforce these new requirements on a state level. As such, the Office of the Attorney General of the state of Texas has chosen to do so, together with the help of the Texas Health and Human Services Commission, the various healthcare provider licensing agencies, the Texas Health Services Authority, and the Texas Department of Insurance. In essence, they're imposed new breach notification requirements on a larger class of entities for information that is also more than just protected health information under federal definitions. This includes sensitive personal information, which we'll discuss in a matter of moments, that can include first name and first initial and last name with other identifiers that would enable someone to perhaps use or disclose information inappropriately based on identifying information obtained. The bill also provides for consumer access to electronic health care records in a shorter time frame than that required by HIPAA. That typically has the 30 days with an option for an extension. Under these rules, to the extent possible, the new statute requires that consumers be able to access those records in 15 business days. This parallels the existing requirement for physicians in the state of Texas. And with all new legislation, there's a creation of new state agency regulation, audit, and enforcement, and the requirements that covered entities meet new notice and authorization requirements. Here's the definition provided for in the Texas Medical Records Privacy Act. Section 181.001, Section 2 of the Texas Health and Safety Code provides a very broad definition for a covered entity. In essence, anyone who practices or organization practices assembling, collecting, analyzing, using, evaluating, storing, or transmitting protected health information, comes into possession of protected health information, obtains or stores protected health information, or as an employee, agent, or contractor of an individual or organization described above, is now deemed to be a covered entity for Texas purposes. As I often ask when I present this, I challenge the audience to look at this definition and attempt to identify someone who isn't a covered entity now under the state of Texas. There are some exceptions, and we'll discuss those with regard to workers' comp programs, some educational records, and also some employee benefit plans. But for the most part, aspects of this new legislation are applicable to almost every individual or organization doing business in the state of Texas. Accordingly, Section 602.054 of the Texas Insurance Code also broadens to include covered entities, a number of insurance entities, with the exception of workers' comp programs. Marketing is another aspect of the definitions and scope that have been enhanced. Under federal requirements, and the marketing section could be a presentation unto itself, marketing typically can be permitted under federal requirements with some permissions granted. Under Texas requirements, it's very important to seek the advice of counsel before entering into any kind of marketing scheme that involves protected health information, as any direct or indirect remuneration, however inadvertent, can subject a covered entity to enforcement issues. House Bill 300 also modified the Identity Theft Enforcement and Protection Act. In doing so, sensitive personal information has been enhanced to include protected health information. Sensitive personal information is also subject to state privacy law requirements. Sensitive personal information by Texas definition is an individual's first name or first initial and last name in combination with any one or more of the following items, if the name and the items are not encrypted: Social Security number, driver's license number or government-issued identification number, or an account number or credit or debit card numbers in combination with any required security code, access code, or password that will permit access to an individual's financial account. Subsumed within the definition of SPI is also protected health information. That information that identifies an individual and relates to the physical or mental health or condition of the individual, the provision of health care, or payment for the provision of health care to the individual. In essence, Texas has both broadened the definition of covered entity and broadened the definition of that information that is covered by the statutory requirements. Next slide. Training is now required. This will be a crucial part of one of the first steps of implementation of the new requirements. Under Section 181.101 of the Texas Health and Safety Code, a covered entity is required to provide training to every employee regarding federal and state requirements concerning protected health information. This includes some employees that might not have been subject to training because the requirement seeks to impose a kind of awareness throughout an organization that enables even that employee who may inadvertently come across sensitive personal information or protected health information in the course of employment, that employee would be aware of the proper procedures for things like breach notification or responding to any complaint or other privacy law compliance issue. Texas requires that the training be specific to a covered entity's course of business and the employee's scope of employment, and that training must be provided within 60 days of the hire date. With this legislation going into effect September 1 and the first 60 days having terminated November 1st, it's very important that all entities get up to speed on seeking training opportunities, getting documentation in place, and updating policies and procedures. Covered entity employees then must receive this training every 2 years. An employee is required to sign a statement verifying attendance at training and maintain a record of this signed statement. Maintenance of that record would be in keeping with the 6-year requirement of other federal privacy law documentation. Next slide. Consumer access to electronic health records. The Texas legislature was particularly interested in ensuring that individuals had swift access to their information, and as such, they adopted a statutory requirement that is in keeping with the existing rule for physicians in Texas. Any healthcare provider using an electronic health record system that's capable of fulfilling the request must provide an individual with their records in electronic form within 15 business days after the date of receipt of the written request. This is not required if the records fall within any of the provisions for mental health records. There will be considerations there, of course, for whether or not this is a danger to the patient, et cetera. And I would direct entities to abide by the protocol defined at 45 CFR section 164.524. Next slide. The Texas Health and Human Services Commission Executive Commissioner under the statute may propose rules for standard electronic format for release of electronic health records. They will do so in consultation with the Texas Department of State Health Services, the Texas Medical Board, and the Texas Department of Insurance, as informed by the Texas Health Services Authority. Under the statute, the Texas Office of the Attorney General is to maintain a website. This is not yet in existence, but will be soon, as there are deadlines coming up within the next 6 months. On the website, consumer privacy rights are to be delineated under both the federal and the state law. There will be a list of state agencies that regulate covered entities, detailed information regarding each agency's complaint enforcement process, and contact information for each agency for reporting violations in accordance with Chapter 181. In essence, the front line of enforcement will be the licensing entities, the Med Board, Nursing Board, et cetera, for fielding complaints or issues that come as a result of these new requirements. From there, each agency is permitted to pursue this, and according to certain statutory guidelines, at their discretion, determine whether or not a case needs to be referred to the Office of the Attorney General for further or additional enforcement. The Attorney General is to file a consumer complaint report. It was very important to the legislature that there be constant communication about the efforts made to protect protected health information within the state of Texas. Each state agency is to submit information to the Office of the Attorney General regarding any complaints they receive, and the AG is to compile this information regarding these complaints that it and other agencies receive in an annual report, and this is to be submitted to the legislature. The AG will de-identify this information before submitting the report. Also under the statute, the sale of PHI is prohibited with some very limited exceptions. This, again, is an area that requires close scrutiny and will be very necessary to consult with any in-house counsel or retained attorney regarding where this is permitted. Under federal requirements, with permission from the individual, typically there can be some sale of PHI. The Texas law has removed that individual discretion. A covered entity may not disclose identifying protected health information to another person in exchange for direct or indirect remuneration, with certain exceptions. To another covered entity, certainly for treatment, payment, healthcare operations, or performing an insurance or HMO function, and is otherwise permitted by state or federal law. But it's important to look for any remuneration, direct or indirect, that it truly falls within treatment, payment, or operations, and that it doesn't exceed the covered entity's reasonable cost of preparing or transmitting the protected health information. That reasonable cost, of course, as we know from the Office of Civil Rights, is not to include any time spent by personnel in gathering that information, but merely the cost of preparation and transmittal. New notice requirements come about, and this is the first. A notice of authorization is required for each electronic disclosure of protected health information. And in general, there is to be a notice, a general notice, placed at the place of business, on the website. I suggest this can be incorporated in an updated notice of privacy practices that enables individuals to know that, in general, their information, even for treatment, payment, or operations purposes, may be disseminated electronically. A covered entity may not disclose protected health information electronically without a separate authorization form from the individual or his or her representative for each disclosure, unless it's for treatment, payment, operations, insurance, or HMO function, or otherwise authorized under state or federal law. This will be particularly directed, for example, at email communication with a healthcare provider. Should any provider receive a written email or other request for information that is to be responded to electronically, it is necessary to have the individual complete a form for each request. January 1 of 2013, the OAG is to produce the standard form for this electronic disclosure. Again, this is not applicable to certain insurance entities. Breach notification requirements. In addition to training, the new notice form, this is a major part of the new requirements. This is a considerably more stringent requirement than that required by HITECH, although it does model those provisions. Any person who conducts business in Texas or owns and licenses computerized data that includes SPI, not just PHI, must disclose any breach of system security to any individual whose SPI was or is reasonably believed to have been acquired by an unauthorized person. This is a somewhat more onerous standard than the harm analysis one might do upon any breach of the security system. Under federal requirements, there's typically a review of what occurs to determine if indeed any harm has resulted. Under the Texas standard, that harm analysis is all but removed. It becomes necessary to notify individuals about a breach upon discovery of any inappropriate use or disclosure. This extends from Texas residents to out-of-state individuals. It will require upon a breach to determine to the extent that an individual's information has been compromised. If that individual resides out of state, it will be necessary to determine if that state has similar breach notification requirements. And if it does not, it will be necessary to locate and provide that notice to the individual. At this point, we do not have rules in place to determine what the manner of that notification should be. Certainly, written notification would be the preferred method for documenting that you've met these breach notification requirements. Within the next year, many of the questions posed by these requirements should be answered by rules that will be promulgated by the Health and Human Services Commission. Enforcement. The OAG may continue to seek conjunctive relief to prevent unauthorized release of protected health information, but now may seek civil penalties with enhanced penalty fines. It's $5,000 for each violation that occurs in a single year, however inadvertent, that is the result of negligence of an individual employee or a pattern or practice by an organization. $25,000 fine for each violation that occurs in 1 year that is knowing and intentional, and $25,000 for each violation in which the covered entity knowingly or intentionally used protected health information for financial gain. Again, it's necessary to look at the marketing requirements and the sale of PHI requirements to determine compliance and to ensure that financial gain may be the subject of knowing and intentional action via a contract. The total penalty for violation of 181.154 regarding authorization for electronic disclosure of PHI, and that's back to the form that is required to be completed for each request for electronic disclosure. This penalty is capped at $250,000 annually. if, and these are the mitigating factors, if the disclosure was made only to another covered entity without the individual authorization form, the PHI disclosed was encrypted or transmitted using encryption, the recipient did not release or use the PHI, and that can be verified by documentation, or at the time of the disclosure of PHI, the covered entity had, quote, developed, implemented, and maintained security policies, including the education and training of employees' response. This will be important in looking at updating policies and procedures and providing this new training requirement. Having that document in place, having taken measures to update policy and procedures regarding both privacy and security will be seminal in mitigating the effects of any audit or enforcement action. If courts find that violations have occurred with a frequency as to constitute a pattern or practice, they may assess up to a $1.5 million penalty. Violations of this nature may also subject a covered entity to mandatory exclusion from all state-funded health care programs. Again, the OAG may only institute action against a state-licensed covered entity if the agency refers the violation to the Attorney General. The AG may also seek injunctive relief to prevent unauthorized release of sensitive personal information. Those civil penalties related to breach notification requirements are $100 per individual to whom notification is due for each consecutive day that person fails to take reasonable action to comply with the breach notification requirements. It becomes very important then to avoid costly consequences, to train employees, and to promote an organizational awareness of the need to notify in the event of breach, be it use or disclosure. The total penalty for violation regarding the authorization for electronic disclosure of SPI is capped at $250,000 for all individuals to whom notification is due after a single breach. Failure to comply with breach notification requirements is a state jail felony if the information accessed, read, scanned, stored, or transferred was protected health information. Disciplinary action. As we discussed earlier, the front line of enforcement will be the licensing agencies. Covered entity licensees are subject to investigation and disciplinary proceedings by licensing agencies for violations of Chapter 181, including probation and suspension. If violations are egregious and constitute a pattern or practice, the agency may revoke a covered entity's license or refer this matter to the Office of the Attorney General for an action for civil penalties. This becomes very important within a healthcare organization to understand that we're looking at the medical board, the nursing board, and all of the various boards that are involved with your individual licensees. On an organizational level, to the extent that you have a single licensed employee that may have an investigation or an action against them, this can have implications, of course, for your organization. It'll be important that your licensees also have this training and that there is coordination in and among licensees as well as non-licensed employees and staff regarding response to complaints, the designation of the privacy or security official to receive those and to coordinate with the licensee should an event occur. Covered entities, again, are subject to mandatory exclusion from all state-funded health care programs if a court finds a pattern or practice of violation. Audits of covered entities. This provision ensures that the state agencies work in coordination with and monitor any federal actions that may occur. The Health and Human Services Commission, in coordination with the Office of the Attorney General, the Texas Health Services Authority, and the Texas Department of Insurance, may request the Department of Health and Human Services to audit a covered entity. Health and Human Services Commission must periodically monitor and review any federal audits of covered entities and may require any pattern or practice or egregious covered entity violators to provide results of a risk analysis self-audit or request that any state licensing agency audit a particular covered entity. The Commission will submit annual reports of all federal and state audits of state covered entities to the appropriate standing committees of both the Senate and the House. Again, it's key to this legislation. The Texas legislature would like to be kept apprised of efforts occurring both at state licensing agency levels, through the Commission and the AG's office, of any and all complaints that occur at a federal or a state level. Standards for electronic sharing of protected health information will be established in great part by the Texas Health Services Authority. This is a public-private organization that's responsible for coordinating the implementation of health information exchange, strategic and operational plans for the state of Texas. This entity has been working feverishly since the legislation was passed to create those standards, to propose them, and to permit a number of committees and stakeholders the ability to weigh in on what those electronic standards should look like. THSA must develop these privacy and security standards for the electronic sharing of PHI and then submit them to the Health and Human Services Commission for ratification. They will be incorporated in the Commission rules and applicable to all covered entities. THSA will establish a process of certification of compliance with these standards in the future, and this will permit covered entities to submit to a form of accreditation by which they can acquire a stamp of approval, if you will, from THSA that certifies both their current compliance and past compliance with these requirements. Funding. This legislation is funded through federal grants. This was a big incentive with the high-tech provisions to encourage states to assist the federal government with enforcing privacy requirements and affording greater rights to individuals at a state level. Health and Human Services Commission and TDI, Texas Department of Insurance, in consultation with the Texas Health Services Authority, has a statutory mandate to apply for and actively pursue federal funding for this enforcement. Finally, we discuss mitigation. What will be mitigating, be it an audit, investigation, or enforcement action by the AG's office, will be evidence of good faith efforts to comply with state privacy law requirements and efforts to comply with HIPAA standards as well as the high-tech provisions. One of the key things to look at when first encountering these requirements is a checklist of items that you will need to ensure that you are meeting both the federal and the state requirements. Having these things in place, practices and documentation, will help mitigate the effects when one of these actions comes about. One of the first things that's important to do is to update current policies and procedures to reflect the intent to comply with the Texas requirements. It's also important that your policies and procedures include the new breach notification requirements, training requirements, how sensitive personal information, not just PHI, is to be handled, and any other aspects of the Texas requirements that are applicable to your organization. Next, it's important to update the Notice of Privacy Practices to reflect 15 business days access to electronic health records, as well as to incorporate the Notice of Electronic Disclosure that is general. It's also important to have in place the form necessary for an individual to authorize electronic disclosure of information that is not for treatment payment operations. And it's also necessary to get in place training that coincides with the tenets of your policies and procedures and is provided to every employee. Of all of the requirements, this one is probably the most urgent and the place to start. That documentation is to be maintained in employees' files along with your other HIPAA compliance and high-tech compliance documentation, and is to be maintained separately with those documents. In addition, of course, you'll maintain your security risk analysis and other federal documentation that's currently required. With those documents, training, and procedures in place, these are key to getting ahead of these requirements and making sure to mitigate the effects of any action or complaint that may occur. For further information or to ask any questions about other documentation that's needed or the implications of these requirements for doing business in Texas and with out-of-state entities, my contact information is provided, and I'd be happy to answer any questions.
Amanda, thank you very much. I'm sure everyone very much appreciates your insight and expertise. We do have several questions already. We are going to hold them to the end of the presentation, but I do ask for the attendees to please submit your questions now via the Q&A function on the right side of your screen so that we can address them at the end of the presentation. Now I would like to introduce Mr. Darren Peterson, Senior Solutions Specialist for Fair Warning. Please welcome Darren Peterson.
Thanks, Allison, and thank you very much, Amanda. We really appreciate the value that you're providing to the attendees today. Like Allison said, we did see a number of questions come in, and I'll be sure to leave plenty of time so that we can address those plus others. My colleague, Chuck Burbank, who was scheduled to present today, was unable to attend, and so I'll try to fill his big shoes here and just have a couple of minutes of content to try to kind of loop this all together. You know, it's really that time of the year where many organizations are starting to take the time to conduct some internal reviews of policies and procedures, their compliance with these ever-emerging state and federal regulations. And I just wanted to provide some thoughts about, you know, some of the important items that should be on the list or in consideration for part of that conversation. You know, as you can see here, I'm going to let you read the agenda for yourselves of what I'm going to briefly cover over the next few minutes. And we'll quickly step through the highlights of each area and, you know, leave some time for questions at the end. And really how this user activity monitoring and retention and meaningful use all relates down to a lot of these not only state but the federal regulations. So I wanted to briefly start with this concept of user activity monitoring, which we've been hearing a lot about lately. And if you're not already a customer or very familiar with what it is that Fair Warning delivers, I'll be brief. It's this third-generation monitoring technology where we are enabling our customers at the provider level to centralize many audit logs that contain PHI along with authoritative user data from HR-type systems into a central repository, and then really providing compliance and privacy with the ability to, if we kind of start at the top of the slide here, to automate these manual processes around patient access reports and user reports, looking across multiple systems for all the access to a specific patient or by a specific user, enabling our customers to be more proactive in their approach in monitoring for inappropriate access by authorized users, whether that's snooping or identity theft or medical identity theft, and then giving them a tool to collaborate and document an investigation if and when they do find something that's suspect, and putting them in a legal defensible position so that they can show and document what's happening internally. And we're also providing with the compliance team with some effectiveness tools so that they can measure what's happening internally, where the training should be applied, where they may need to apply some sanctioning, so that board-level reporting is right within the product. And as most of you know, we have a vast amount of experience with these healthcare applications. We have a Fair Warning Ready for Healthcare program where we work to certify extraction methods with many of the vendors that you see on this list and others. And so hopefully that gives you a good overview. We're working currently with a little over 1,000 hospitals and 3,500 clinics at this point. And if you have questions, we can discuss those near the end here. So in addition to the Texas laws that we've been talking about today, you really don't have to do anything extra to comply with HITECH and HIPAA, kind of like Amanda was saying. It's just an extension of, and also to prep potentially for a visit by the OCR. We do have quite a few customers actually that have experienced these audits firsthand and have really helped us here at Fair Warning to identify exactly where Fair Warning maps to those published protocols and those requirements. And so you'll see some links on the slides. One of them goes to the OCR site to list out those protocols, the other maps where Fair Warning addresses those. These will be in the PDF that we send out as a package tomorrow, as well as it will contain the contact information for Amanda. And so hopefully that'll be helpful for you all that haven't yet reviewed them. As I'm sure you know by now, you have to have appropriate technology in place to really be fully compliant with any of these particular sections, unless you're at a very small organization, and then a well-documented manual process is more of a best practice. But it sounds obvious, but that the practice of this is much more difficult, and that's that the technology should be active and in use. The policies, the written policies, should be active and current. And as these governmental auditors say, the ink should not be wet when they walk in the door, nor should they have to blow the dust off of them when you pull them from the shelves. And so when we talk about things like these policies, just make sure that they're updated. Now is a great time to go through, especially as the laws continue to emerge and cement, to make sure that you're in the right space for your department. And really, what's important here is that you should really think about documenting and justifying which systems or which applications or electronic health records that you are monitoring and which ones you aren't and why. We know firsthand that it's very important to document these for potential auditors about the reasons why you are not auditing a particular system and basically ranking them in priority for your organization. Our customers are focused on this best practice of retaining data, and whether that's for 6 years around HIPAA privacy rules, that those are records and audit logs, and that's where Fair Warning really helps our customers to have a place to store those logs. We understand that that could adjust down with the Omnibus package, but either way, the procedure storing that data should really be in place. And if you're not currently extracting and storing audit logs, if they're being overwritten after 30 days or 90 days, that's something that you should seriously consider implementing for your rules. And then finally here, there's been a lot of focus on meaningful use over the last couple years, and as that relates to privacy monitoring, it's really about completing that risk assessment. It doesn't have to be third party. It needs to be done on a regular basis. So if it's something you did 2 years ago, it's probably something that you want to pull down and redo. And identifying the gaps within those and addressing those. We've seen that user activity monitoring or patient privacy monitoring is always among them if something isn't currently in place. And really also part of this is that the application vendors now have some skin in the game. You know, they're being asked to actually turn on an audit log, to enable it, to make it available to customers. And so we're seeing a large increase in the number of application vendors that are producing a log that's valuable, that has good information in it. And obviously, Stage 3 is pending, and it's anticipated to have more privacy and security rules that will be included. And, you know, obviously, Fair Warning will publish those as they come out, and you'll see another link here that will make sure that we distribute as we go here. So, Allison, I think we have a lot of questions for Amanda. Do you want to turn it back over to you?
Great, we do, and thank you, Darren. We do have several questions that have come in, and again, in our time remaining, I'm going to bring both Amanda and Darren back to relay a couple of these. Please remember that each attendee will receive an email within 24 hours with a link to the material presented today and a recorded version of this webinar. So we do have several questions for Amanda in particular. Does House Bill 300 or the state of Texas mandate a monthly review of the OIG GSA checklist for employees of a covered entity?
It does not at this time.
I'm sorry, Amanda, I think your phone is a little bit muted, but I believe you said it does not. Is that correct?
It does not. There are currently no rules or regulations in place. We only have the statutory requirements. But of course, as you all are doing, we're monitoring here any proposed rules that come about and what that is looking like in the near future.
Okay, thank you. And another question for you, Amanda. Is there a state agency that providers must notify of an unauthorized disclosure of EPHI similar to the OCR for HIPAA breaches?
There is not. At this time, there is only individual requirements in terms of notification that those go to individuals. Do we anticipate that coming perhaps in the future to the Office of the Attorney General or licensing agencies? That is certainly one of the mechanisms that's being contemplated.
Thank you. I have another question for you. Can training be in the form of CBT?
You will have to help me with CBT.
I believe it's computer-based.
Oh, certainly. Yes, it can be live by webinar. It can be in the form of CBT. There is no prescribed method or manner for that training or link for that matter. The only prescriptions at this point are that it cover both federal and state requirements, that it be specific to the business and specific to an employee's scope of employment.
Okay, great. And more questions for you. Can healthcare organizations extract selected employee health information, specifically EPHI, such as immunizations, and update an online portal through Lawson or PeopleSoft, for example, for employee access?
Yes. The idea is as long as an individual has access, you have encryption or a portal or something in place. The key here is not necessarily the method at this point, but if there are breaches that occur, that individual notification be provided.
Okay, and then a follow-on question with that first one. Does the same organization need written permission from an employee to be able to access that database? And a tandem question, can appropriate HR staff manually update an employee portal with EPHI?
Yes. The idea of the form for electronic disclosure has to do with things that are apart from operations, and particularly when we're looking at employee benefit programs or employment records, that's permissible.
Okay, great. I have two other questions for you, Amanda. To whom do these new requirements apply?
Well, I would take a very liberal approach to whether or not something applied under the broadened definition of the Texas covered entity. All but a workers' comp program, some educational records,
and some employee benefit plan records. Those are the only individuals or organizations that are exempted from the requirements. Basically, everyone from law firms to now governmental entities are covered entities where they weren't considered to be that before.
Interesting. And we have one last question. Can you please comment on the implications for dealing with out-of-state business associates and covered entities?
Yes, this is going to be an issue when you've got to get records out to consumers, when you're dealing with requirements that may not be in place with out-of-state entities. Just as we have a number of provisions applicable to doing business in Texas, to the extent that other covered entities interface with Texas, they'll be required to abide by enhanced requirements by Texas entities. For example, when you put your business associate agreements in place, even if you've got an out-of-state vendor or an out-of-state provider, it'll be important that those business associate agreements include an agreement to abide by Texas breach notification requirements and any other rules that are proposed and adopted in compliance with Texas requirements.
I'm sorry, Amanda, we have one more question.
Sure.
If subchapter 241 states access must be provided within 15 days of receipt of a written request, House Bill 300 further defines the 15 days as business days. Could the practiced 15 days going forward cause any issues?
It's certainly going to create some personnel and some time management issues in terms of the need to get those turned around in less than the 30 days that we're accustomed to. It's going to create some issues in getting accustomed to doing that. It may require the hiring of additional personnel or increased job duties for other employees to ensure that that requirement is met.
And Amanda, I believe that's all the questions that we have come in so far. If you have additional questions, please do send them to us. I want to thank Amanda Ellis very much for her time and her expertise. I'm sure the attendees appreciate it very much. And I would like to again remind the attendees that you will receive an email within 24 hours of the conclusion of this event. If you have any additional requests, you can reach us at fairwarning.com. Again, thank you so much to Amanda Ellis for your time, and we thank you all for attending. Have a wonderful afternoon. This concludes the webinar.